The Roger Rogoff dismissal is more than a personnel story. It is a constitutional stress test involving the boundaries between the executive and judicial branches of the U.S. government. On July 16, 2026, Roger Rogoff, a veteran prosecutor and former judge, was sworn in as the court-appointed U.S. Attorney for the Western District of Washington. Less than an hour later, the Trump administration informed him by email that he had been removed. Rogoff is considering legal action, making this a potentially significant constitutional case. Here are several deeper insights that legal scholars, historians, and political scientists would likely focus on. 1. The dispute is really about institutional power, not one individual. Most news coverage frames the story as Trump fired Rogoff. The deeper question is, open quote, when Congress creates a backup appointment process involving judges, can the president immediately nullify it? Close quote. Federal law allows district judges to appoint a U.S. attorney if the position remains vacant after an interim appointment expires. The legal uncertainty is whether the president's constitutional removal authority overrides that judicial appointment immediately. That issue has not been definitively resolved in this precise context. 2. The Constitution intentionally creates productive friction. Political philosophers from Montesquieu to James Madison argued that liberty is protected when government branches compete. The American system was never designed for maximum efficiency. It was designed so that Congress checks the president, courts check both, the president checks the courts. Seen this way, the Rogoff dispute is not necessarily evidence the Constitution is failing. It is an example of the constitutional system being tested under conditions of institutional conflict. 3. A constitutional convention can become fragile through repeated exceptions. Experts in constitutional law often distinguish between written law, constitutional norms. Many government practices are sustained because office holders voluntarily follow long-standing conventions. If repeated departures from convention become accepted, tomorrow's exception can become tomorrow's normal. Historians sometimes describe this as constitutional hardball, using every legally arguable advantage while disregarding informal traditions. Nadar 4. Personnel control is a form of policy control. Economists sometimes summarize organizations with the phrase, open quote, control the incentives and you control outcomes. Close quote. A president cannot personally supervise thousands of federal investigations. Instead, influence often comes through appointments and removals. That makes disputes over who occupies key offices strategically important because personnel choices can shape enforcement priorities across the executive branch. 5. The real legal question is about precedent, not just this office. Experts are watching because a lawsuit could clarify broader principles, such as how much removal authority the president has over court-appointed U.S. attorneys, whether statutory appointment mechanisms meaningfully constrain executive power, how courts should balance Article 2 presidential authority with statutes enacted by Congress. A judicial ruling could affect future administrations regardless of political party. 6. History suggests institutions matter more than personalities. Political science repeatedly finds that democracies are more durable when institutions are stronger than individual leaders. The identity of today's president is less important in the long run than the rules governing presidential authority. Future presidents of either party could invoke precedents established today. 7. This reflects an enduring tension in political philosophy. Different traditions emphasize different values. Thomas Hobbes emphasized strong executive authority to preserve order. John Locke emphasized limiting executive power to protect liberty. James Madison sought a balance, assuming ambition would counteract ambition. Modern constitutional disputes often revisit this centuries-old question, open quote, how much executive power is enough to govern effectively without undermining the system of checks and balances, close quote. 8. Experts separate legality from wisdom. One of the most important habits of constitutional scholars is distinguishing. Can an action legally be taken? Is it a prudent or beneficial exercise of that authority? Those are different questions. An action may be lawful, unlawful, or legally uncertain, and people may still disagree about whether it is wise, effective, or consistent with democratic norms. Why this case could become historically significant ting. If Rogoff proceeds with litigation, the case could become an important test of the relationship between presidential removal authority under Article 2, Congress's statutory appointment framework for U.S. attorneys, and the judiciary's role in filling vacancies when the normal appointment process stalls. If appellate courts, or ultimately the Supreme Court, address these questions, the resulting decision could influence the balance of power among the branches for years to come. At present, however, that outcome remains uncertain. The deepest lesson is not about Roger Rogoff or Donald Trump alone. It is about how constitutional systems evolve. Major constitutional developments often emerge not from sweeping amendments, but from disputes over specific appointments, removals, and institutional powers. Those cases can gradually define the practical boundaries of government authority for future generations. Number 10. This is an example of a constitutional gray zone. Many people assume the Constitution answers every major question. It doesn't. The Constitution is only about 7,500 words long. Much of the U.S. government's day-to-day operation depends on statutes passed by Congress, judicial decisions, historical practice, and constitutional interpretation. The Rogoff dispute arises because these sources can point in different directions, leaving genuine legal uncertainty rather than a simple right or wrong answer. Number 11. Government power often depends on control of information. A U.S. attorney is not merely a lawyer. That office oversees investigations involving public corruption, organized crime, national security, corporate fraud, civil rights, environmental crimes. Control over leadership in such an office can influence priorities, resource allocation, and strategic decisions. The issue is less about individual cases than about institutional direction. Number 12. Institutions develop their own cultures. Organizational psychologists describe a phenomenon called institutional memory. Career prosecutors may serve through multiple administrations. Political appointees often serve for shorter periods. Because of this, tensions can arise between long-term professional norms and changing policy priorities set by elected leaders. This dynamic exists in many democracies and is not unique to one administration. Number 13, the separation of powers was designed to be inefficient. Modern organizations usually aim to reduce friction. The U.S. Constitution intentionally creates some. For example, Congress can slow the president. Courts can review executive actions. The president can veto legislation. This friction was intended to reduce the risk of concentrated power, even though it can also make government slower. Number 14, the appointment process reflects a concern about continuity. Congress created a mechanism allowing judges to appoint an interim U.S. attorney after certain vacancy conditions are met to help ensure that federal prosecutions continue even if the executive and Senate have not completed the usual appointment process. The current dispute centers on how that statutory mechanism interacts with the constitutional authority to remove executive officers. Number 15, constitutional disputes often become symbolic. Political psychology shows that people often interpret institutional conflicts through broader narratives. The same event may be viewed as defending executive authority, protecting judicial independence, preserving checks and balances, or challenging established norms. People's broader constitutional philosophies often shape how they interpret the same facts. Number 16, incentives can matter as much as rules, best friend. Economists emphasize that formal rules are only part of the picture. Officials also respond to incentives such as career prospects, public reputation, legal risks, political accountability, professional ethics. Understanding institutions often requires looking beyond written rules to the incentives facing decision makers. Number 17, history shows that institutional precedents accumulate. Individual cases may seem small at the time. Later, courts and lawyers may cite them when resolving similar disputes. This is one way constitutional doctrine evolves gradually rather than through dramatic changes. Number 18, public trust is an institutional resource. Political scientists often argue that institutions depend not only on legal authority but also on public confidence. If significant numbers of people lose trust in courts, prosecutors, elections, or executive agencies, those institutions may find it harder to carry out their functions effectively, even if their legal powers remain unchanged. Number 19. Democracies constantly balance independence and accountability. There is an enduring tension between two important goals: ensuring prosecutors can make decisions based on law and evidence, ensuring that executive officials remain accountable to elected leadership. Different democracies strike this balance in different ways, and reasonable legal scholars may disagree about where the balance should lie. Number 20. Why legal scholars will watch any litigation closely. If the dispute reaches higher courts, judges may need to address questions such as, how should Article 2's executive powers be interpreted alongside Congress's statutory appointment framework? What limits, if any, can Congress place on presidential removal authority for this type of office? How should courts interpret statutes that interact with constitutional powers? Any answers could shape future disputes involving appointments and removals, extending well beyond this specific case. The broader lesson, the Rogoff matter, illustrates a recurring feature of constitutional government. The balance of power is often defined not only by the constitutional text itself, but also by statutes, judicial interpretation, historical practice, and institutional norms. Cases like this attract attention because they can clarify or reshape how those different sources of authority interact over time.